Yes, Mr. Barrett.
Thank you, my lord. My lord, can I just check, do I have 30 minutes or 45 minutes? I'll need to...
Take your time.
Thank you very much. My lord, I'm turning then now to explain why the, if I can just use this language broadly, the objective approach of the tribunal I respectfully submit is incorrect in law, and why that is not an answer to the appeal. My lord, could I ask you to look at the tribunal's reasons which are expressed in their reasons for refusing permission to appeal? It's the core bundle, tab 9, at page 162, paragraphs 14 and 15. The court will see that the legal and conceptual basis of the tribunal's justification of its approach is to say that it is supported or required by the Court of Appeal's judgments in the Sky Blue case and the Bulb Energy case. To unpack that, my lords, that is an argument, firstly, that on its true construction, the Subsidy Control Act, section 3.2 specifically, has incorporated in substance the EU state aid law market economy investor principle, the MEEP. And secondly, the consequence of that is that rather than reviewing a decision of a public authority under section 3.2 on the basis of the evidence before the decision maker, at the date of the decision, the court should have regard to prior material, later material, materially in this case, the Walmsley paper, which you have seen and heard submissions about, in order to form its own objective conclusion as to compliance with the law. My lord, my essential submission is that those authorities do not support the tribunal's approach. That's for 3 reasons, 2 short reasons and then 1 which requires development. And the first short reason is the one that I've explained in submissions this morning. This EU state aid law MEEP principle is concerned with the applicable legal test for outcome rationality challenges. It is the equivalent of our substantive Wednesbury irrationality challenge. It does not apply, has no application to discrete public law challenges, such as, in this case, the claim in relation to breach of section 79, or the claim regarding failure lawfully to follow the applicable policies. Those are freestanding public law breaches of duty, are subject to domestic public law principles. The EU state aid law MEEP principle is not relevant in respect of those grounds. The consequence of that, I say, is that even if the respondent or the tribunal was correct that section 3.2 incorporated the MEEP principle, it would not be an answer to the other grounds of claim. That, I say, my lords, is usefully illustrated by the Sky Blue case itself. I'm not going to turn this up because of time, but please can I just give you the references. My lords will see that the grounds of judicial review advanced in Sky Blue are summarised within the High Court judgment at paragraphs 81 to 82. The reference for that is tab 11, page 337. And the court will see that ground 4 was a contention that the decision to approve the loans was flawed due to regard to irrelevant considerations. Now the court held, this is paragraph 139, that's at page 353, that the relevant decision maker was required by our domestic public law principles to have regard to all legally relevant considerations, referring to the National Health Association case, amongst other authorities, the very principles we rely upon in this claim and appeal. The argument that the defendant had unlawfully failed to do so failed on the facts, that's paragraph 141 to 158, but as to the legal principle, that claim is one in respect of which the court did adjudicate those principles do apply to decisions of this nature. There was no appeal on those issues, and consequently that point is not considered in the Court of Appeal's judgment, but it is, in my respectful submission, objectively, obviously correct. Secondly, my lord, this is the second reason, we respectfully submit that even if the tribunal was correct that section 3.2 incorporated the MEEP principle, that would not justify the analysis which the tribunal applied. The MEEP principle does not permit the reviewing tribunal to conduct its review on the basis of material post-dating the decision. For that proposition, can I ask you to turn up a judgment of the CAT? It's the new lottery case, which you'll find at Authorities Bundle, tab 19, at page 569.
So what was the second half of that proposition?
Even the MEEP principle, my lord, does not authorise the reviewing tribunal to consider material created after the decision. The required analysis is still focusing on the time of the decision. So it's tab 19, and if I could ask you to turn within the report to page 593, and it's paragraph 75, subparagraph 2. If I could ask you just to take a moment to read that to yourself. So this is all on the premise that we are indeed within the universe of EU law. EU law, different analytical framework, but nonetheless one sees a similarity of approach. And I say that's because the underlying values are similar. There must be certainty, there must be clarity. It's the time of the decision that's the relevant point in time. So my third submission, my lords, and this is a submission that requires some development and a series of propositions that I will put to you if I may, is that the tribunal was wrong to hold that section 3.2 of the Act is to be construed as incorporating the EU state aid law MEEP principle. And that is for 8 principal reasons. The first reason, my lord, is that the provision of the Act governing principles and standard of review is section 75. I've shown you that. That expressly provides, Parliament has expressly provided that claims will be determined on the basis of domestic judicial review principles. Those principles categorically do not include the EU state aid law MEEP principle. We say that is a complete answer and proper analysis to the approach of the tribunal. Secondly, my lord, we say there is no scope, or it would require very clear statutory words to read into a provision of this sort in the Act the scheme of EU law. You recall the submissions that I made in relation to the appropriate approach to construing the Act and the drafting of the TCA, including Article 4, as summarised in my learned friend's trial skeleton argument. One would need very clear words to support EU law being read into the statutory words of the Act. There are no such clear words, and there is not a hint, either in the explanatory notes or any of the admissible aids to interpretation I am aware of. Any part of Parliament's intention was to adopt and preserve an EU law legal principle. Thirdly, if that approach were to be adopted, it would lead to a situation where the court, in the same proceedings before the CAT, this case, for example, would be applying significantly different principles and standards of review to parallel claims brought under the same judicial review jurisdiction. In the MEEP claim, the court would not be focusing on the decision and the material before the decision maker. Matters would be at large. In all of the other judicial review grounds, the court would be looking solely at the decision and the material before the decision maker. Now, I don't say that's impossible, my lord. Judges are clever fellows. We can keep multiple ideas in our minds, but in my respectful submission, it's an indication that is not the true construction of the statutory scheme. Fourth, my lords, we say it would be inconsistent with the operation of the rest of the Act. There are other statutory obligations in the Act. Those are all subject, I don't think there could be any suggestion, to standard public law principle and judicial review. It would be, we say, anomalous, again, would require clear words, if the no subsidy question, section 3.2, were to be implementing a different and inconsistent approach. Fifth, my lords, we say that the suggested approach of the tribunal simply cannot stand with the statutory words of section 3.2. Particularly to those in the course of dealing with the legislative scheme, the statutory words connote an evaluative judgment, might reasonably have been expected to have been available on the market to the enterprise, providing for a reasonable assessment as to what might have been expected. That involves questions of judgment and evaluation. That is the antithesis of a statutory provision conferring a precedent fact jurisdiction. Sixth, my lords, under our system of public law, for reasons of both constitutional principle and also functional reasons, the law allocates responsibility for the primary and initial decision making in relation to matters of this sort not to the tribunal, but to the responsible public authority. Can I show, my lords, the House of Lords authority for that proposition? It's the MMC case which I mentioned this morning. You'll see that in the authorities bundle at tab 4. And you'll see the statement of principle, if my lords have the report, you'll see the statement of principle by Lord Mustill, explained on page 137, G through to H. I can ask you to read that yourselves, and if you could possibly indicate when you've read that.
So this was the question whether a part of the
substantial part of the United Kingdom, my lord.
Yes.
Statute word, substantial part of the United Kingdom. And the substance of the point is, it is a question which potentially admits of more than one rational answer. That is the substance of the analysis. There is not an objectively true or correct answer to the statutory question. That is why it is, in the first instance, for the judgment of the public authority subject to rationality review. And that, my respectful submission, is the same as section 3.2.
It doesn't address that decision. That authority doesn't address the situation where no decision is taken.
It doesn't, my lord. I entirely accept that. It's not about that. I entirely accept that. I have to accept that. But, my lord, I mean, the reason for which I'm currently asking you to consider this is construing, you have to construe section 3.2, in my respectful submission, this is the backdrop, this is the legal backdrop against which you're doing that. Seventh, my lords, the Bulb case, and I obviously say this with considerable diffidence, my lord gave the judgment in the Bulb case, in my respectful submission, does not support the tribunal's analysis, and I will need to show you that judgment in some detail to seek to make that good. Could I ask you to turn that up, please? That's at tab 17 of the authorities bundle. So, as my first point, my lords, and it's really just a preliminary point, it goes without saying, the Bulb case was concerned with the short-lived interim regime following Brexit. It was not and cannot be a judgment about the correct construction of the Act, since the Act was not in effect and the judgment was not grappling with the Act. So to that extent, I submit it couldn't justify or support the tribunal's approach, but I'll also obviously seek to demonstrate that the reasoning does not support the tribunal's approach. Could I ask you to start, please, within the judgment, if you have that, at paragraph 66, which you'll find on page 510.
Can I just go back a step?
Of course.
And ask, the springboard for all this was the reasons given on the permission to appeal.
Yes.
Paragraph 15, that's what you took us to.
Yes.
All that says is they relied on the consistent line of authority, the Sky Blue sports case and Bulb Energy.
Yes.
But bulb energy paragraphs referred to are 104 to 106.
Yes.
Which just, most of those are about the standard review in the Court of Appeal. So
I respectfully agree with that, my lord. I think there's been some confusion. What I understand them to be saying, and I think certainly, I think they must be saying this, I think, in substance, is that they say your substantive analysis on the MEEP question, I don't know if my lord recalls, or you've...
I have no recollection of the MEEP question at all, so
No, I'm sorry. I believe they understood or believed that they were supported by your reasoning that I'm about to show you.
Right, okay.
And I'm going to seek to demonstrate that I'd say that's not actually correct. But my lord, I accept that. I think the cross references might not be quite right. But I think I do need to meet. It seems to me I need to meet this case. It seems to me. So if I ask my lords to look at paragraph 66, which is the beginning of my lord's analysis, that's on page 510, and my lord is considering what is required of the UK by its obligations under the TCA. What's the UK required to do? If I could ask my lords just to look at that, read that to yourself. And that is indeed, so we respectfully say that's the starting point, as I sought to explain in my earlier submissions. If I could then ask you to look at paragraph 73 and the first sentence, you'll see that my lord, again, respectfully, my submission correctly points out that there is no requirement to go beyond domestic judicial review principles of review. At paragraph 75, my lord notes that the TCA is not required to be interpreted by reference to EU law. My point, no EU law state aid MEEP. At 76, my lord points out that the TCA is satisfied if judicial review is available on domestic public law principles. That's confirmed then by my lord at paragraphs 89 to 90. And Mr. Coppell, KC as he then was, makes a submission to you that the only available judicial review ground is rationality. My lord rejects that, again, my submission correctly. It's not confined to rationality, it's the full panoply of orthodox judicial review grounds of challenge. And then if I could ask my lord to look, and my lord to look at 92, where my lord deals specifically with the MMC case. And the principle that my lord states in my respectful submission is the key principle to this question. Where you have an issue that gives rise to essentially scope for different views, the court applies rationality review under our domestic system of administrative law. Now at 96, you then note that there is an analogy between our domestic system and EU state aid law. The analogy, in my respectful submission, my lord is noting, is that on questions where there is scope for different reasonable views, EU law also acknowledges and applies a margin. The conclusion of your reasoning, my lord, is at 97. Now you there refer to sky blue, and this is what I understand to be the basis of the tribunal's reliance on your judgment. The tribunal is saying, as I understand it, that the Court of Appeal in this paragraph was saying that the UK was required to, and or did, pursuant to the interim regime, adopt the EU law MEEP principle. Now, I respectfully say, my lord, and obviously I'm not going to tell you what you said in your judgment or meant in your judgment, that's not, looking at those paragraphs that I've shown you, the reasoning or conclusion that you're adopting. Indeed, that proposition is positively inconsistent with the observations that you've made in those paragraphs I've shown you. TCA doesn't require us to apply the MEEP principle. TCA only requires domestic principles.
Can you just tell me again what the MEEP principle is?
Oh, I'm sorry. Market economy investor principle. It's,
right.
it's just the EU label, jargon.
Yes. What does it mean?
It means, amongst other things, well, for present purposes, our purposes, what matters, the tribunal says it means I'm not reviewing a decision based on the material that's before the decision maker. It means I'm at large. I can look at anything I want.
Right.
That's the salient difference.
I don't recall that being an issue at all. But
I respectfully agree.
Yes.
The shape. I mean, I don't want to go too far into the history, but the whole context of Bulb was that on the one hand it was being pressed upon you by the appellant, the claimants, that there was just no margin, was the point. No margin, just court make up its own mind. Court of Appeal rejected that in Bulb, in my respectful submission, correctly. So I say, on true analysis, contrary to what the tribunal thought, and what my learned friend says, it's not a judgment at all that supports incorporating the MEEP in section 3.2. It's a judgment against that. It's a judgment that tells us, looking at your reasoning, the passages I've looked at, that there is no basis to be reading EU law principles into the Subsidy Control Act.
I can't see here any reference to EU principle.
It's a sky blue case, my lord. That's the
Well, the
that's the MEEP.
but what is being talked about in this case is
Does my lord mean? I'm terribly sorry.
in the Bulb case.
Yes.
Is domestic law principles.
So can I try and explain, my lord? So what's going on specifically is that this is dealing with a case where we're in the interim period between Brexit and the new Subsidy Control Act coming into operation, and there's a specific statutory provision which essentially says during this interim period, the provisions of the TCA will have direct effect in domestic law to the extent it's necessary to give them effect. So that's the background to it. And then what's said by the claimants is that the effect of that, the court should say, is that the TCA requires us to apply the MEEP, the EU principle, and that's then given effect through this conduit pipe in the Act, and that's the standard that we're applying in domestic law. That's the point.
But I mean, I'm struggling a bit.
Sorry.
Because we haven't really looked back at what it's about. But at 84, Lord Justice Zacaroli refers to section 71 and 5 of the Act that we're looking at.
Yes.
And refers to the High Court deciding it by
Yes. Yes, which I would respect.
power principle.
Yes. Which is one of the reasons, my lord, I say that the tribunal or the respondent is wrong to think that Bulb is an authority which supports the application of the MEEP principle.
But there doesn't seem to be anything in the reasoning which says I'm now going to refer to a broader EU principle, procedural principle, i.e. looking at everything by way of background as you push it.
So that is the MEEP. But
MEEP is just a test of whether something is a market rate or not, which is rather similar to
yes. So
the words of 3.2. It's just saying...
It's how you do it, my lord. It's how you do it. So the point is, it's the EU law principle of review. So I'm sorry, I haven't perhaps sufficiently explained this or developed this. It's a legal standard for review, and there's a whole... If my lord wanted to look at a textbook of EU stated law, you would find a chapter or half of a chapter that would give you specific rules about what the MEEP requires and what the standard and approach to review is. The point I'm trying to explain is that the tribunal's approach, this notion of objective analysis, we look at everything in the round and make our mind up, that is the EU law standard of review under the MEEP. And the reasons I showed you in the PTA decision make clear that the tribunal's basis for saying that that was the correct approach for them to adopt was that that MEEP principle is to be, as it were, applied, read into section 3.2. And I'm explaining in my submission, A, that's not correct, and B, it's not an analysis supported by Bulb. Bulb doesn't say that the UK is under any obligation pursuant to the TCA to apply that standard of review. To the contrary, I say Bulb is clear authority, properly read, that the only obligation under the TCA is to provide for domestic judicial review, principles of review. Hope.
I think what I'm missing is the premise of the argument against you. I don't see how you get out of paragraph 15 of the reasons for refusing permission to appeal.
Well, perhaps,
the idea that...
yes, perhaps I should wait to hear what my learned friend says. Well, so I understand that to be the essential basis of the tribunal's decision as to what the correct approach is. And what I also say is, just following on from that, my lords, if that's not the essential basis for the tribunal's conclusion that that's the correct approach, what is the legal or conceptual basis? Two authorities are mentioned, Sky Blue and Ball, and those are meat cases.
Well, I thought Ball wasn't a meat case. You just made.
Well, it said. Yes, well, there we are, my lord.
Yes.
I agree. I agree. It's not a meat case. My lord. Ninth submission, in terms of the construction of the statute, is there a requirement under the statute to conduct consideration of whether financial assistance gives rise to a subsidy? We respectfully submit that there is. That is the proper construction of section 12 read together with section 3.2 and 2, and the implicit obligation is to conduct a reasonable assessment of whether financial assistance which satisfies the elements of the subsidy subject to compliance with section 3.2 constitutes a subsidy. Now, the applicable principle of statutory interpretation, we say, is illustrated by the House of Lords decision in the G and Barnett case. That's the loose leaf House of Lords authority that I have handed up to you. Could I ask you to turn that up?
Sorry, can I understand the submission again? Sorry.
Yes.
You're saying that, is this right? It's implicit in 3.2.
Section 12 read with 3.2 and 2.
Sorry.
Of course. That there is a requirement to conduct a reasonable assessment as to whether financial assistance which you're providing is a subsidy. Just to state it very shortly. I'm going to show you.
So reading those sections together, there's
Yes.
an implicit requirement
To consider whether financial assistance that you're providing is or is not a subsidy. And if my lord could pick up the Barnett case, which illustrates the principle of statutory interpretation we rely upon. So my lords have that. Just to show you, perhaps I could ask you to look within the report's internal page numbering. I could ask you just to look at page 220H, paragraph 20, just so that you can see the duty that the House of Lords was concerned with in that case.
What's the bundle reference?
It's not in the bundle, Lord. This is the loose leaf.
Oh, right, sorry.
And it's the G London Borough of Barnett case.
Yep. Page
220, my lord, and if you go to H in the side lighting. This is just to show you the statutory duty that the court was concerned with. A very broad duty, what's often referred to as a target duty. That's just so you've got the provision and you can understand the analogy or contrast. And then if I could ask you to look, please, at paragraph 32, which is at page 223H within the report. Could I ask you to read the judgment of Lord Nichols, and he explains how and why there is implicit within that duty a duty to conduct a reasonable assessment in the first place as to whether a child is or isn't within the scope of the duty. If I could, when you finish that, if I could then ask you, please, just to look at paragraph 110, which is Lord Millet. That's at page 245B, and the analysis is the same effect.
The question in this case was whether the local authority discharged its duty by considering the welfare of children as a class. And the question was whether there was a requirement to assess the individual children, as I understand it.
So the facts actually are rather complex, my lord. There are sort of a number of different cases. Can I just seek to give you as direct an answer I can as to what these paragraphs are dealing with? These paragraphs are dealing, and the proposition that one takes in these paragraphs is that in circumstances where the relevant statutory provision either, and this is Lord Nichols' conclusion, imposes a duty to support children who meet the criteria, or in Lord Millett's construction, gives a power to support children who meet the relevant definition, there is an implicit duty to assess, conduct a reasonable assessment as to whether a child does or doesn't meet the relevant criteria, and that's the principle that those aspects...
But it's about the question, isn't it, whether on its proper construction, the section requires an assessment of individual children,
yes,
or children within the area as a class, and the
individual
court decided it was individual children.
Yeah.
But is that anything more than just a general exercise of statutory construction? In other words, what's the principle that you get out of it?
The principle is that when Parliament has imposed a duty on a public authority to do a particular thing, if defined statutory criteria are satisfied, there is an implicit obligation to reasonably assess whether the defined statutory criteria are or are not satisfied. And the reason for that, my lord, is in the passages that I've shown you. It's explained in my respectful submission by Lord Nichols. Absent that implied obligation, Parliament's legislative purpose, to use Lord Nichols' language, would be stultified. If there is not an implicit obligation to conduct a reasonable assessment, the duty that may be triggered depending on the conclusion of such assessment will or may never be discharged where it ought to be discharged. So I think at all disagree with it. It's exercises statutory interpretation, but the principle that's being deployed, the principle that those passages stand for, I respectfully submit is applicable to the provisions that we're looking at here. And those are for the reasons I sought to explain, my lord, in my legislative structure section. If assessments are not conducted, there will not be compliance with section 12. There will not be compliance with section 33. Challengers will not be able to exercise statutory rights, and as and when anyone does bring a challenge, there will not be reasonable evidence to allow the proper and orderly adjudication of those challenges. So I say, my lord, that's my submission. I say it's implicit in the statutory scheme read as a whole. I say that's supported by the contextual factors I've just sought to summarise. Well, can I just make just a very final short point on this section? As a matter of fact, it's not a matter of law, but as a matter of fact, the two cases which the tribunal relies upon, Sky Blue and Bulb, are both cases where there was indeed a proper assessment by the responsible authority as to whether what was being done was a subsidy or not. My lord may or may not recall in Bulb, that was by the Secretary of State in Bulb. And in Sky Blue, I'll give you the reference if I may actually for Sky Blue, I have that to hand. It's Authorities Bundle 13, page 363, paragraph 10. You see that there is both external legal advice and commercial advice that went to the council decision-making body on that question. It's not a point of law, my lords, but I do say it shows you how these things are done, how these things ought to be done. My lord, final point under these grounds, we also say that the CAT erred in conducting what amounted to its own de novo analysis of compliance with section 3.2. That is not the approach, the correct approach we see under section 70 for all the reasons I've sought to explain. It's a review jurisdiction. It's not the CAT exercising its own judgment. That would be an appeal jurisdiction. I suspect members of this court will be familiar. There are some statutory schemes where that is what Parliament does. If there's an appeal jurisdiction, that's not what's been done here. It's the judicial review jurisdiction. Could I just give you a series of references, please, where I say that you see the CAT doing that? Within the judgment, paragraph 193 sub 1, 193 1A, 193 1E, 194 4, 194 5. And in each of those passages, my lord, you will see the CAT forming its own view about the commerciality and sufficiency of aspects of the transaction. Matters which the responsible decision maker never had before and never considered, matters which Mr. Walmsley didn't analyse or consider in the way that's done by the CAT. It is the CAT, and one understands that may be what they considered they were required to do, but we say, my lord, that is de novo decision making or appeal. It's not what this jurisdiction, what this statute provides for. My lords, can I then turn to my final head? My lord, I'll need to be very, very brief indeed. My final head is failure to have regard to relevant considerations. My lord, firstly, the Maslow loans. I briefly outlined the relevant facts in my opening. With a very short point. These are loans granted to Mr. Whittaker's SPVs by a true market lender. They were entered into at the same time as the club loans, which were advanced by Mr. Walmsley as the main justification for the commerciality of the rates being charged on these loans. The Maslow loans were at roughly double the interest rate charged by GMCA on the Collier's Yard and Blade loans, roughly double. And that was so in circumstances where Maslow had insisted on having entities of substance, entities with real money, real assets, give cross guarantees to support the lending, whereas the GMCA lending was to unbacked SPVs. My lords obviously put to me there are factors referred to briefly by the CAT they say is justified discounting the relevance of the Maslow loans. Two essential points on that, my lords. Firstly, there is no explanation or justification of the 3 points mentioned. Pardon me, 3 points, that's the first point. The second point is that the evidence they relied upon was an email from Mr. Whittaker appended to the respondent's responsive witness statement without any statement of truth or statement of compliance. I said it was inadmissible. My learned friend did not deal with it. I say it was inadmissible in circumstances where it wasn't supported by a statement of truth or compliance. It shouldn't have been relied upon at all. There is no evidence provided by the authority at all on this. The relevant witness statement, Blakey 5, she simply appends the email from Mr. Whittaker and invites the court's attention to those points. Third point, my lords, I've made already. I do say the tribunal had to deal with the fact that the interest rate was double that of the GMC lending and the cross guarantees. There has to be some sort of rational or lawful effort made to deal with that. One can't simply look at one side of the, in my respectful submission, one side of the equation. You would need to deal with both the positive and negative factors. We say this was a relevant consideration. That wasn't disputed at the level of principle. What was said was not comparable, not relevant. For the reasons I've explained, we say it was relevant and ought to have been considered. The failure to do so was unlawful. Second point, my lord, relates to viability assessments. It's a very short point. Mr. Whittaker, for this specific investment, in order to obtain his planning permission and exemption from an affordable housing obligation, submitted a viability appraisal which indicated that this development was unviable. So not only a low profit return, but so low as to be below the viability threshold. That was used as the basis to obtain exemption from the affordable housing obligation from Manchester City Council, one of the constituent members of GMCA. For the purposes of seeking this funding, he submitted starkly inconsistent viability appraisals which showed substantial profitability, and that is said to be part of the justification for the rates being compliant with the Section 3.2 principle. Now, at the same time, in parallel with that, he also submitted in relation to one of his other city centre developments, evidence saying that the market situation had substantially deteriorated from the time of the first viability appraisal, i.e. things had gone down, not up. And we say in that context, that inconsistency was, again, a relevant consideration. It was within the knowledge of MCC, who is a constituent member of GMCA. It was a relevant consideration that should have been taken into account and should have been considered as part.
That would have been something that was submitted to the planning authority.
It would accept that, my lord. It would be in their planning capacity.
That's a different person normally from from those who would be considering this kind of.
In terms of the individuals, yes, I don't think I could dispute that. But we do say what matters at that level of analysis is the authority.
But is there any evidence that the authority, that this committee, which was deciding this question, was aware of those?
There is evidence that the Mayor was aware, my lord, because a letter was written to him, and we can provide that if it's of assistance. So that in terms of the Mayor himself, Mr. Burnham, he was sent a letter. There is no evidence as to whether he read it. But as I say, if the letter...
And that was before the 27th
It was,
March.
I believe, I'll check that, but I believe it was, my lord, yes, I believe it was.
Right.
And then the third point, my lord, very shortly indeed, we say that concentration risk was a relevant factor for the purposes of assessing the market rate. So my lords have seen the facts. Broadly, around 50% of the entire fund going to two SPVs with a single ultimate beneficial owner. We say that doesn't necessarily preclude the loan being made, but we say certainly, rationally, it is a relevant consideration to pricing, because obviously, to put it very colloquially, a lot of eggs, almost half of one's eggs, are going into a single basket. We see that does affect the risk analysis and the pricing of the risk analysis.
Does it? I mean, that's why is it different if the fund had been much, much bigger? You're still inserting this amount of money into that basket.
So, my lord, in terms of quantification and analysis of risk, again, we don't have the evidence before you, there's some evidence below. My understanding is it is indeed an accepted part of bank lending financing that the greater part of one's fund or pool is being allocated to either a single transaction or a single counterparty. That is regarded as something that goes. There's I don't have the precise reference. There's a document called a Basel Convention that was in the bundle below that supports that proposition. I can't take that point much further than that at this stage, I don't think. So that's my final submission in relation to that. Just before then I sit down, could I seek to answer Lord Justice Zacaroli's question you asked me this morning? If I were to lose, as it were, on my challenge regarding all my challenges regarding is this the correct approach? Do I have I think you're putting me, do I have a freestanding challenge? I think in terms of my grounds of appeal, I think I don't, the petition. My lords, I don't know if I can be of further assistance. Could I just check if there's anything?
No, thank you very much.
Thank you.
Yes, Mr. Robertson.
My lords, I'll just explain how I hope to structure my submissions. The first thing I would like to do is just take the tribunal back to the Act to make some points about interpretation of the Act. Secondly, I'd like to address the tribunal on the standard of review both here and in the CAT. Thirdly, I think it would be helpful just to take the court through the CAT's decision and just go through it section by section and address points that have been made by my learned friend. He's been picking out particular points. I think it's just helpful to read the tribunal from start to finish. And then, fourthly, I'll address my learned friend's grounds, which have now been compressed essentially into number 1, his former ground 4, number 2, grounds 5 and 6, number 3, grounds 1 to 3, and then 4, the ground that he's just dealt with, which was ground 7. So first of all, to deal with the Act. It's helpful to have that in front of us. Authorities bundle. Tab 1. My learned friend's taken you to the genesis of this Act, which is the Trade and Cooperation Agreement, which you have, or the relevant extracts you have in tab 3 of the Authorities Bundle, and the learned friend is taking you to the subsidy control principles in Article 366. Perhaps just to go back to back to tab 3, page 95, to see where this sits. It sits in a chapter in that part of the Trade and Cooperation Agreement that deals with a level playing field for open and fair competition, and that Chapter 3, Subsidy Control, sets out decisions, including, at the top of page 96, subsidy means financial assistance, and then at, just by the first hole punch, subparagraph 2, confers an economic advantage on one or more economic actors. The Trade and Cooperation Agreement came in to replace the EU state aid rules that had been applicable up to formally 11 p.m. on the 31st of December 2020. And the agreement, the Trade and Cooperation Agreement between the EU and the UK, replaced, insofar as the UK is concerned, the previously applicable EU state aid rules. There sits above the Trade and Cooperation Agreement World Trade Organization rules on subsidies. So there's an overarching obligation on the UK as a newly independent WTO member on leaving the EU to comply with the WTO agreement on subsidies and countervailing measures. So the UK gives effect to the Trade and Cooperation Agreement as part of giving effect to its international obligations under the WTO. So the Subsidy Control Act, which then gives effect to the TCA, is not a self-standing piece of domestic legislation in that it was only inspired as a matter of domestic policy. It sits against this international backdrop. So turning to the Act at tab 1, we see that the key provisions for our purposes are, first of all, on page 4, subsidy, defining subsidy at subsection 1 of section 2 as financial assistance which, and then B, confers an economic advantage on one or more enterprises. So there you see it picking up the TCA language. The next relevant subsection is subsection 5 on page 5. For the purposes of this Act, financial assistance is to be treated as given to an enterprise if the enterprise has an enforceable right to the financial assistance. So, financial assistance is given where there's an enforceable right to the financial assistance. We then come on to section 3, which, and particularly subsection 2, which we, of course, have looked at. If we just do a page turn, I'm not going to dot around, I'm just trying to take this sequentially. The next relevant provision, and this is one that my learned friend laid a lot of weight on, is section 12 on page 11. And it's in part 2, subsidy control requirements, chapter 1, principles. Section 12 is headed application of the subsidy control principles. The subsidy control principles are applicable to determining the legality of a subsidy. And put in very broad terms, subsidies have to be considered for their applicability, their compliance with the subsidy control principles. Those subsidy control principles are set out in Schedule 1 of the Act, and when one looks at that, that's on page 66, you'll see there the subsidy control principles set out. And they're in quite broad terms. So they require subsidies to pursue a specific policy objective, to be proportionate, subsidy control B, designed to bring about a change of economic behaviour, subsidy C, and so on. You then also see in Schedule 2, an additional range of subsidy control principles that are applicable only in the area of energy and environment subsidies. There's no need for us to go into them, but you see they're set in very broad terms. And the point is that when a public authority is granting financial assistance as a subsidy, then it has to address its mind to compliance with these principles. And so when we turn back to section 12 on page 11, we see there the requirement in subsection 1 that a public authority must consider the subsidy control principles before deciding to give a subsidy, and must not give the subsidy unless it is of the view that the subsidy is consistent with those principles. So what we're talking about is compliance of financial assistance with those broad principles. And that's classic discretionary decision-making by public authorities. Section 12 does not indicate anything about whether financial assistance is or is not a subsidy. That's not what's addressed at.
I suppose a point you might make about that section is that there Parliament has specifically legislated requiring the public authority to consider something, namely the subsidy control principles, and it has used that very clear terminology where there is a positive obligation on the authority to consider a question.
Yeah. Exactly. So when my learned friend says that there's a duty to make a decision applying section 3, subsection 2, which is implicit in section 12, he's incorrect. That's not what section 12 is doing, and it can't be read in that way. So, what is section 3, subsection 2 doing there? Why doesn't it set out some sort of positive obligation on the public authority to make a decision whether or not something falls within section 3, subsection 2? Well, to understand that, why is that legislation set out in the Act? It's useful to compare the position that applied under the EU state aid rules. My learned friend was reluctant this afternoon to say that MEOP means CMO under section 3, subsection 2, but it does, it's the same, it's the equivalent principle. We'll have a look at the authorities that say that. He calls it MEEP, I call it MEOP, Market Economy Operator Principle. Those are the terms that are used, MEOP, MEEP, CMO, as we now have it. The MEEP or MEOP principle was developed in the case law under the state aid rules by the jurisprudence of the European Court of Justice. So it's not something that you see written into the Treaty of Rome, which is where the state aid rules first made their appearance. And it's not something you see written into any primary legislation at EU level. It's court-made. It's a principle developed by the European Court to distinguish between matters which are state aid and matters which are not state aid because they're just commercial investments. They're rational commercial investments. Under EU law, under the state aid rules, we applied that jurisprudence in determining whether or not something was state aid. And that was a question for a court to decide. The reason why you can't rely upon that EU jurisprudence to make that distinction under section 3, subsection 2, is precisely that which was explained to you by my learned friend. The trade and cooperation agreement replacing the EU state aid rules is quite clear in saying this agreement is to be interpreted in accordance with principles of international law, specifically the Vienna Convention on the Law of Treaties. And that was a distinction that was drawn by those who negotiated the agreement, the UK, perfectly clear in its negotiating stance. We need to make it clear that we're out of the EU regime. We can't have the European Court of Justice legislating in a way that could be then taken to interpret our domestic law. That's not the purpose behind the TCA. So the Subsidy Control Act needed to replicate the underlying principle that found expression in the MEOP, or MEEP, and put it into primary legislation. Otherwise, the UK would be starting from scratch with no clear guidance given as to how you approach commercial investment by public authorities. So that's what Section 3, subsection 2 is doing there. That's why you can't say this replicates a provision of the Treaty on the Functioning of the European Union. It's an EU-based approach which has been effectively replicated in our primary legislation. Now, I said that this was court-based. I'm going to come later on to the Sky Blue Sports and Bulb Energy cases and more recent cases from the tribunal. But just to take it back to the EU state aid rules, could I ask you to pick up the authority that I handed up this morning called Lund-Polly and the Commissioners of Customs and Excise, which is a Court of Appeal judgment what this case was concerned with, and it's quite useful to see the distinction between the approach, the case law approach to interpreting the extent of the state aid rules. The case concerned a tax rate that had been introduced to introduce a higher rate of insurance premium tax on certain types of insurance premiums, where the concern was that the providers of certain products, in this case it was package holidays and travel insurance, there was an incentive because of a lower rate of insurance premium tax for insurance than applied under value-added tax. That if you were selling to a consumer a holiday plus insurance, reduce the value of the holiday, increase the price of the insurance, the overall cost is the same, but the supplier of the package holiday and the insurance pockets the VAT saving. It was known as value shifting to Customs and Excise, and so an attempt was made to remove the incentive to do this by increasing the level of insurance premium tax on certain types of supplies up to the VAT rate. Lund-Polly, well-known travel agency, or provider of package holidays, sought to challenge this on the basis that it was being punished for the supply of travel insurance supplied together with a package holiday by comparison to suppliers of travel insurance who weren't tied up to package holiday suppliers. They could carry on supplying insurance premium tax at the lower rate, insurance at the lower rate of insurance premium tax, and that gave them a competitive advantage. And so the argument was run by Lund-Polly that was a state aid to the lower rate taxpayers. So that's the background to it. I'm very fond of this case because it was my first state aid case at the bar. I made the switch from teaching at Oxford to practice at the bar in the mid-1990s, and found myself brought in first of all by Sir Ken Parker, as he now is, and then Paul Lassop to act for Customs and Excise. So I know quite a lot about the case. But what I can say is no thought at all was given by Customs and Excise Commissioners as to whether this was a state aid when this tax avoidance scheme through the higher rate of insurance premium tax was brought in. It just wasn't conceived of as being caught by the state aid rules. Unfortunately for Customs and Excise, they came up against, as you can see on the report on page 354, Gerald Barling. So Gerald Barling, as you know, is former president of the Competition Appeal Tribunal, of course, and the late James Flynn, who successfully argued that this was state aid to the lower rate taxpayers. And that's an argument that won in the divisional court, it won in the Court of Appeal, and the point I wanted just to draw to your attention was that we ran an argument for Customs and Excise that it would have been reasonable for Customs and Excise to take the view that this wasn't state aid. There could have been some discretionary decision, and that was dealt with right at the outset by Lord Wolfe on page 358 at G to J. It was clearly appropriate. The legality of the statutory provision contained in Act of Parliament cannot normally be examined before the courts. However, the provision of national legislation conflicts with the requirement of the treaty. It's the responsibility of the domestic courts to provide a remedy of the type granted by the divisional court in this case. If the provision which is contravened is of direct effect, it's accepted that the last sentence of Article 93(3) of the Treaty of Rome is of direct effect. That's the provision that says if a member state does grant state aid, it can't do so without the approval of the European Commission, either through an individual decision or through a block exemption. Whether or not there has been a contravention of the final sentence of Article 93(3) can only fall to be determined if the court decides for itself whether or not the matters complained of constitute an aid which should have been notified to the European Commission. The fact that the Commissioners believe that they have acted legitimately in promoting the legislation cannot decide this issue. So that's where you get the expression of the underlying concept of EU laws, that the difference between something being an aid or not an aid is an objective decision for the court to decide. Or as my Lord Justice Nugee said shortly before the short adjournment, it's a justiciable matter.
But there it's directly applicable EU law.
Yes.
But that's not our situation.
No. But it's still the approach that we take to making the distinction between whether something's a subsidy or not a subsidy, applying Section 3, subsection 2. It's an objective matter, it's a justiciable matter for the court.
But the reason it's a justiciable matter in that case was because there was a directly applicable law.
Yes.
So how does that help you?
Because in looking at what how Parliament intended Section 3.2 to be interpreted, did it intend there to be a radical change from the previous approach under the state aid rules? Answer, no. There's nothing in the legislative history or in the statutory guidance or in any other ministerial statement that I have been able to find, and I'm sure my learned friend would have found it if there was, to say this is a complete change from the approach we took to MEEP or MEOP under the state aid rules. On the contrary, the CMO principle is to be approached in the same way. Not because of direct applicability of the EU law treaty article. No. That's what Section 3.2 was intended to do. It had to be there because you couldn't just have relied upon pre-existing EU case law to say you take the same approach. Therefore, it needed that statutory expression.
I mean, I couldn't help reading on in this case and seeing, if you go over the page to 359, after that long passage, he says that the question is one for the court. But he then goes on to say, this is not an isolated situation for a court or an application for judicial review to have to do this. The same task has to be performed whenever the legality of the conduct of public authority depends on a question of what's conveniently described as precedent fact, when he refers to the Kawaja case.
Yes. And that passage starts off, the role of the domestic court having been identified in this way, in that judgment, I have no doubt that the role of the court is to come to a decision for itself, whether or not there's been a contravention of the final sentence of Article 123.
So do you submit that this, looking at it through the, forget about direct application, because that's not our case, looking at it through still looking at it through the prism of JR, it may be necessary for a precedent fact to be determined in order to decide whether there's been unlawful conduct by the public authority, namely whether it's a subsidy.
And that is where, as we'll see, the case law says, right, when you're approaching whether someone's made a commercial investment, a market economy investment, that can admit of a number of different views. And that range of views is for the court should recognise and respect that. And it's only where plainly it's not a commercial investment does it fall outside the concept of MEOP meet CMF. And that's the way in which it operates as objective, and then the court in decision making has to recognise that there are a wide range of different circumstances. It's only if you're plainly outside that it would then become state aid or a subsidy. And just before we lay, I'm not going to go back into the detail of unlawful, but just to give the final context to that case. I think it's a really interesting case because it provoked a lot of litigation as across a wide variety of areas. Litigants argued, well, we're the subject of differential treatment and it has an adverse financial consequence to us. Those that benefit by comparison, they're receiving state aid. And so there was a wave following Lund Poly, a wave of litigation. That came to a juddering halt with the follow-up case to this, which was called Gill Insurance. This was, Gill Insurance was about insurance for rental TVs. Shows, it was 30 years ago when people still did rent TVs and were required to take out insurance for them. The value shifting was perceived to take place there, so that was also an area where the higher rate had been introduced. There was litigation brought in the VAT tribunal by Gill Insurance, that's Granada Insurance, Granada, a leading rental TV supplier at the time, to recover amounts to be paid by way of higher rate insurance premium tax. That ended being referred to the European Court by the VAT tribunal. That was Mr. Lassock, myself, and Mr. Tim Ward, now the joint head of Compton Chambers, with junior counsel to Paul Lassock. And I think what Paul Lassock, KC, still regards as his greatest triumph, we convinced the Court of Justice that differential rates of tax weren't a state aid to the low rate taxpayers because they were justified by the nature of the tax system. And the reason why that's got to read across is that that particular, the reason why I just mentioned the Gill Insurance case is that it shows that there can be a justification for differential rates of tax, and that brought that litigation, that wave of litigation, to an end. And so there have not been that many state aid challenges since then, and no successful ones, so far as I'm aware of. I've been involved in a few unsuccessful ones. And I mention that simply because my learned friend this morning rightly pointed to the impact assessment, the subsidy control bill, where it had been predicted that you could expect to see 15 to 30 subsidy control challenges coming before the Competition Appeal Tribunal a year when the new Act comes in. And I think he sort of indicated, well, you know, the bar's been set too high by the CAT, that you should somehow reduce it. It's only to say that for a lot of us practicing in this area, we thought that impact assessment was way too gloomy about the number of challenges. That it wasn't. If you looked at the experience of the state aid rules, once the parameters are worked out, it's no more fertile an area for litigation than any other area of public law, possibly less. So I just mentioned that.
Can I just ask you about this?
Yes.
Mr. Jackson drew a distinction, I think, when we were looking at the 4 different parts of the question, is this a
Yes.
subsidy? Between those like B, which involve a range of possible commercial answers, and others which are more binary.
Yeah.
What was the precise issue then that was the precedent fact in the Lund Poly case? It's talking about the last sentence of that Article 93.3. It seems to be just about whether the proposed measure has resulted in a final decision. Is that the point?
I'm not sure I could recall off the top of my head. The key point about Article 93.3 is the last sentence of Article 93, paragraph 3, was the obligation on a member state to notify a state aid to the European Commission and obtain approval from the Commission before putting it into effect. So it may be that's the...
Well, the sentence reads, the member state concerned shall not put its proposed measures into effect until this procedure has resulted in a final decision. That's the wording.
Yes.
I'm not quite sure I follow it.
If I can help that. My lord, I think you're looking at the standstill provision. So I think that's the procedural obligation not to implement the measure.
Yeah.
I think my lord's question is quite right. I think the question the court's looking at is not the section 3.2 question. It's not the judgmental question. It's a more hard-edged objective point.
Well, I'm just trying to find what it talks about the last
Yes.
final sentence of 93.3. The question is, has there been a contravention of it? Where is that? Is that what we see at page 357?
Well, there was a contravention because it had not been notified.
Okay.
Yeah. And it's because essentially the commissioners hadn't, right at the outset, taken the view that this was even conceivably within the state aid rules.
But anyway, this is not dealing with the sort of precedent fact we have in our case,
No.
which is this a loan on commercial that a commercially market operator would enter into?
That particular point about 93.3, no, because there's no equivalent standstill provision.
Yeah.
And you appreciate that under the state aid rules, everything that if it was a state aid had to be notified, approved by the Commission. All control was exercised by the Commission over state aid within the entirety of the European Union.
Yeah.
It's a very, very centralised approach. The Subsidy Control Act has a very decentralised approach, as you've seen from the subsidy control principles.
Yeah.
Public authorities make
But your proposition, I think, your argument is that the wording at the bottom of page 359 about the general position in relation to determinations of the precedent fact would apply to 3.2.
Yes. Yeah. And that it's an objective matter for the court to determine which is 358. So, having indulged me with that trip down memory lane, I go back to. So I was in the Act, and I had explained that Section 12 doesn't have the effect for which my learned friend contends. Then, if yes, sorry, and the final point that I wanted to make it just on the early sections of the Act is the point that I've made about the Gill Insurance case, saying that essentially if differential rates are justified by the logic of the tax system, again, that's judge-made law at EU level. It's given effect in the Act in Section 4. It sets out a domestic equivalent of that. So just as 3.2 does that, Section 4 does for tax measures Again, it's because you can't simply just apply the EU jurisprudence, because the TCA is interpreted in accordance with principles of international law and is not to be exclusively interpreted in accordance with the law of any of the parties to the agreement. So with that, if I turn over to so just to complete the sort of the view of how the Act operates, we've looked at where a public authority does conclude that it's granting a subsidy and it then makes an assessment subject to subsidy control principles. There's then a role for the Competition and Markets Authority to give advice upon that assessment for larger levels of subsidy. And you see that on page 37, part 4 of the Act, CMA referrals and functions, how the CMA responds to that, and there are some referrals are mandatory, other referrals of lower level are voluntary. That's section 56 of the Act on page 40. And then we get up to enforcement, which is on page 51. And here this is Part 5 enforcement, appeals to the Competition Appeal Tribunal. Subsection 1. We've not really looked at this. An interested party who is aggrieved by the making of a subsidy decision may apply to the Competition Appeal Tribunal for a review of the decision. Now, my learned friend has sought to portray this as being part of, actually, it's a broad-ranging right to seek judicial review of anything which is essentially subsidy-related or financial assistance-related and enables you to bring in the whole panoply of public law. In our submission, that goes too wide and it's inconsistent with the wording of section 70, subsection 1. So first of all, it relates only to a subsidy decision. So for that, there's got to be a subsidy decision. It doesn't apply to other decisions. So if something's not a subsidy, it's not a subsidy decision, it's not within section 70, subsection 1. And it's not a general right of judicial review with the broad approach to standing that we have in the administrative court. It's limited to, first of all, an interested party. And that's defined in subsection 7 as meaning a person whose interests may be affected by the giving of the subsidy or the making of the subsidy scheme, in respect of which the application under subsection 1 is made, or B, the Secretary of State. So there aren't public interests. There's no public interest ground for bringing an application. It must be someone whose interests may be affected. The statutory guidance gives the Department for Business and Trade's view that essentially means competitors that they draw it a bit further than that. Anyway, it's for the court to decide who is a person whose interests may be affected by the giving of the subsidy, but it's not a more general right to challenge. Subsidy decision, it goes on to state.
The applicant in this case is a competitor?
They're certainly a potential competitor of Mr. Whittaker's company.
There's never been any challenge to standing?
No, we've made no challenge to standing. So we see subsidy decision means a decision to give a subsidy or make a subsidy scheme. So it's limited to a decision to give a subsidy. It doesn't run wider than that. So it's not giving the Competition Appeal Tribunal the same jurisdiction as the administrative court enjoys in judicial review. It's limited to subsidy decisions. A third point to make is what's not here. There's no permission requirement. Unlike the administrative court, where an application for judicial review may only be brought with permission of the administrative court, there's no permission stage. So you can, as Malone and Friends clients did, simply make an application to the tribunal. There aren't even court fees at the tribunal. So you submit your application and the tribunal then has to deal with it. So in our submission, this doesn't have the breadth of application for which Malone and Friend contends. It's a specific statutory regime designed to deal with subsidy decisions, challenges to those brought by interested parties as defined by the Act. And Malone and Friend says, well, that's all very unattractive because you may have a case where there's a subsidy decision challenge to the tribunal, and then there's also a parallel judicial review, which of course permission would be sought. Well, the answer to that is that's not an unusual situation. One gets it under the Competition Appeal, the Competition Appeal Tribunal, under the Competition Act, and indeed in other applications that can be made to the Competition Appeal Tribunal under the Enterprise Act 2002 in relation to merger control and market investigation decisions. It's not unusual to have parallel judicial reviews where there's a question as to whether the decision under challenge properly falls within the jurisdiction of the Enterprise Act or the Competition Act 1998. I think it also happens in procurement cases. You can have parallel challenges both under the procurement regime and then more generally. I think Mr. Barrett's been involved in one recently, the National Lottery case, which he was successful for the interveners being led by my joint head of chambers, Mr. Howard, KC. So that's a feature of litigation, and it's not a reason for interpreting Section 70 as broadly as my learned friend contends. We then go to the appeals decision, appeals provision, Section 75, and as has already been pointed out this morning, an appeal lies to the appellate court on any point of law arising from the decision of the tribunal under the preceding provisions of this part. And the phrase appellate court is used as is made clear in subsection 4. The appellate court in this jurisdiction in Northern Ireland is the Court of Appeal. In Scotland, it's the Court of Session. So we're dealing with a UK-wide jurisdiction. So we shouldn't as it were, narrowly focus on the position in England and Wales. This is the position for a tribunal that's got a UK-wide jurisdiction. Again, another reason for confining it to its proper jurisdiction under Section 70. Finally, in relation to my learned friend's submissions, the final section I wanted to show you, Lordships, is on page 57, under Part 6, Miscellaneous and General, Section 79, Guidance. Subsection 1 provides the Secretary of State may, not must, issue guidance about the practical application of A, the subsidy control principles, B, the energy and environment principles, and then more specific aspects of the Act that we haven't looked at. That then goes on in subsection 2 across the page, page 58. Guidance under these subsections may, in particular, deal with, or any other matter connected with, A, the determination of whether financial assistance constitutes a subsidy for the purposes of the Act. So it's guidance which in practice it's the Department for Business and Trade, which has a subsidy control unit within it. That's where this guidance actually emanates from. Not exclusively, there's obviously cross-departmental issues, but that's, I think, the principal responsibility for authorship lies there. So it's guidance which may be issued, addressing, importantly, the subsidy control principles, because that's a new area that doesn't have a specific parallel in EU law. So that's important that we have that guidance. And it deals with related matters, may deal with related matters as well. In our submission, that would look very, very different if the body offering financial assistance was under a duty in any case of the provision of financial assistance in whatever form to carry out an assessment as to whether it fell within the definition of a subsidy under the Subsidy Control Act. It's not what the guidance is doing.
What do you say about the point in subsection 2A that the guidance may deal with the determination of whether it is a subsidy, and then the requirement in 6 that the public authority should have regard to the guidance?
Yes, when giving a subsidy. So when a public
authority... So can it ignore little to any guidance given in 2A completely and only take it into account for the purposes of B to D in 2?
If a public authority decides to look at the guidance and concludes it's dealing with a subsidy for the purpose of the Act, then plainly subsection 6 says it must have regard to the guidance. But if it's dealing with something which is not a subsidy, well, simply the Act doesn't apply in the first place. So, in our submission, 2A is something which may be included in the guidance. So, the Secretary of State may give guidance as to whether something constitutes a subsidy or not. Doesn't have to.
Suppose it is, though.
Sorry?
Suppose that the guidance does include 2A, i.e. guidance about the determination of whether the financial assistance constitutes a subsidy. So suppose that such guidance has been given.
if the public authority is not dealing with a subsidy, then the obligation under subsection 6 to have regard to the guidance doesn't apply, because that only applies where there is a subsidy.
So the answer is that the public authority is not required to have regard to guidance issued under section 6(2)(a), even though that guidance covers the question whether the financial assistance constitutes a subsidy.
Yes. If it's not dealing with a subsidy, then it doesn't have to have regard. It's not caught by the Act. And public authorities give all sorts of financial assistance, day in, day out. The idea that they should be sitting down with a weighty subsidy guidance document every time and going through that just doesn't make any practical sense. And it's not what this section 79(6) requires it to do. If it is dealing with a subsidy, then yes, it must have regard to the subsidy guidance. It would be obviously sensible for it to, not only required to do that, it would be sensible for it to do so. But if you're dealing with...
It seems an odd construction of the section, because, on the face of it, because the Secretary of State can decide whether or not to give guidance about particular things. One of those is the determination of whether it is a subsidy. The Secretary of State has actually given guidance about that. There's an obligation to have regard to guidance issued under this section. But you say that the public authority is not required to have regard to that bit of the guidance.
Well, if they're dealing with something which isn't objectively a subsidy, then it can disregard the Act.
But isn't there a logical problem here? That it can never know whether it's giving a subsidy unless it answers the question in 2A.
It may not appreciate that the level of the financial assistance might be characterised as a subsidy.
No, but it's slightly broad upon that. 2A, on your analysis, 2A can never ever cut in, because you wouldn't know you're giving a subsidy until you've undertaken that task. So you never get to 6, you never get to giving a subsidy unless you've already decided that actually what you're doing is giving financial assistance does constitute a subsidy.
Well, at that point, if a public authority objectively isn't giving a subsidy and is acting in, just doesn't appreciate that it might be a subsidy and that it might want to have a look at the statutory guidance, it's not in any breach of any obligation in our submission if it goes ahead and provides the financial assistance, which is simply not a subsidy. Because it can't be in breach of subsection 6, because that only applies where it is giving a subsidy. So I think subsection 2A is something which permits the Secretary of State to include guidance as to whether something's a subsidy or not, and that may be quite an important point for the Secretary of State to want to publicise in guidance. Maybe all sorts of reasons in government why you'd want to say we regard this as being a subsidy. But so that's why it's got the power to do that. But if you're asking me if it's an obligation for a public authority in any time it gives financial assistance, always to go through a stage of, well, is this a subsidy or not? Then in our submission subsection 2A doesn't go that far. It doesn't carry with it that implication. And a public authority may just proceed, provide the financial assistance, and if it's not a subsidy, that's of no concern under the Subsidy Control Act. So I think that's as far as I can take that analysis on the face of the legislation.
Can I just go back to your point on section 71, read in conjunction with the definition of subsidy decision in subsection 7 of that section?
Yes.
Where does that take us? I mean, it seemed like where you were leading this was that the CAT had no jurisdiction at all to deal with this issue because there was no subsidy decision. So actually what should have happened was an application to the administrative court.
Well, my learned friend was arguing that he can attack this decision by reference to public law principles. He can. You bring an application for judicial review.
Was this a point? So it's a sort of jurisdiction point. The
Yes.
CAT was the wrong place to take this case. Was that argument run before the CAT?
Well, it was run in the sense that we argued this isn't a subsidy, and therefore, as it's not a subsidy, it's by virtue of section 3, subsection 2, then your application fails.
So in any case of doubt, what does the party do? They have to apply both to the admin court and to the CAT, because you may be right, you may be wrong in either of them.
If it's concerned that it's not got a subsidy decision, then yes, it may need to issue protective proceedings if it wants to apply to bring a more general public law challenge. If it's not got a subsidy, then it doesn't have a subsidy decision. Bear in mind, of course, that most cases where there's a subsidy, then the obligation, the public authority goes through the requirements to determine whether it complies with subsidy control principles. If you do that as public authority, you're then under an obligation. We haven't covered the specific provisions, but there's a subsidy control database provided for under the Act, whereby public authorities register details of the subsidies they're giving. So, and one of the reasons for that is that then sets a time limit running for anyone to challenge and say, no, you shouldn't have granted that subsidy. It's inconsistent with the subsidy control principles. And so you challenge the subsidy decision that way. My learned friends suggested there aren't that many cases. Well, the subsidy control database is replete with thousands of decisions from public authorities, Greater Manchester Combined Authority has subsidy decisions publicised on the subsidy control database. So that's what's being policed.
I think, is this right? Your submission is, this Act is designed to deal with cases where a public authority intentionally gives a subsidy to somebody. It says, here's somebody where, for good policy reasons, we should be giving financial assistance, which amounts to a subsidy. In those circumstances, we have to comply with the guidance, we go through the checklist, we publicise it, and if anybody doesn't like it, they've got a right to go to the CAT under section 70 and so on and so forth. I think your submission is, this Act's not really designed with the current question, which is it a subsidy at all?
That's not our submission.
That's not your submission.
No. Our submission is that it's an objective assessment as to whether something's a subsidy or not, and that is ultimately a question to be adjudicated upon by
the tribunal.
And that was the point of taking...
And if the tribunal comes to the conclusion it's not a subsidy because of the CMO test,
Yes.
then it follows that it wasn't a subsidy decision,
Yep.
and it follows you weren't under any obligation to comply with section 79, and it follows, logically, the applicant fails under section 71 because it's not the making of a subsidy decision. And it doesn't really matter whether you say, and they didn't have any standing because the CAT didn't have any jurisdiction. The CAT's got to decide whether it is a subsidy decision or not. And if it's not a subsidy, it's not a subsidy decision and the application fails, and that's the end of it.
The application is rejected.
And that's what you say happened quite rightly in this case.
Yes.
Okay. Well, I understand the way you put it.
Yeah. And so that was the point of starting off with Lund Poly, which so that's under the state aid regime. That's how that worked. And as we will see, that's how we say it's continued to work under Sky Blue Sports, Bulb Energy, and in more recent cases.
So it is, to use that phrase used in Lund Poly, it is a precedent fact. If it's not a subsidy, there's nothing to see here at all.
It's just commercial investment. Public authorities engage in commercial investment and generate revenue, and that's it. That's of no concern to the subsidy control regime. It's not affecting the level playing field that the Trade and Cooperation Agreement seeks to establish.
And was that the way the CAT resolved it? Because if that's right, what was the point in the CAT spending many, many pages determining whether the process undertaken by the GMCA was compliant with public law principles?
Yeah, it was answering the question, does this fall within Section 3, subsection 2? In other words, is this commercial investment?
Well, not quite, was it? I mean, it did answer that in one paragraph, but only one paragraph. The rest of the judgment is dealing with reviewing the legality of what the GMCA did.
Well, it's looking at the process that was followed by the GMCA throughout to ensure that its lending was on commercial terms and didn't run the risk of being a subsidy. So I don't think it's right to say that the tribunal only focused in one paragraph. What my learned friend has done is to say there was an agreement right at the outset between Mr. Whittaker and Mr. Volton as to the rates, and that was presented as a fait accompli, essentially, to what's referred to in the judgment as the GMCA committee on the 22nd of March, the public meeting, the Part A and the Part B, and that's all there is to see. And the tribunal is saying, no, that's not what happened. This was a process that went through a number of stages. There was approval in principle on the 22nd of March, and then was subject to due diligence. And essentially at any point, this could have been revisited until the loan was actually formally entered into on the 22nd of November. And that was a lengthy process. And the idea that somehow this was one official agreeing the rates and that was it is completely factually wrong. It's my learned friend's case, but it's factually wrong. So that's why they spend so much time going through the procedure, because the procedure is designed to ensure that lending is carried out on a commercial basis. It's quite a well-established procedure, by the way. You may have picked up that this particular fund, these are the 9th and 10th loans to Renaker. There had been 8 previous loans from this fund. Also, this isn't the only fund that the GMCA administers for investment. So things like the interest rate setting paper, that's not unique to these particular investments. When it's described as Mr. Walmsley's paper, it's just a standard process that the GMCA go through. And so that's why I said, when I got to my feet, that one of the things I would do after going through the Act would be then to turn to the structure of the tribunal's decision. I said I was going to do that after addressing you on the nature of review by the tribunal and indeed by this court. So perhaps if I deal with that. So I think that's all I wanted to say in relation to the Act. The next thing that I wanted to go to is review by the tribunal. That was addressed in our skeleton argument. Quite shortly, at paragraphs 7 to 9, we've already picked up on section 75 of the Act. This appeal to this tribunal is on error of law. As to what constitutes an error of law, well, I think we touched upon that in broad terms this morning when Mr. Barrett was opening his case. The best explanation of the approach to be taken to errors of law in our submission is to be found in the decision of the Court of Appeal in La Patorelle, which is in the authorities bundle at tab 18. This so on page 530. This is a decision. It's actually a permission to appeal decision by Lord Justice Green and Lord Justice Nugee. But it's a detailed judgment. It's been given a neutral citation number. And it's an appeal or an application for permission to appeal from the Competition Appeal Tribunal in a Competition Act damages case, collective proceedings case, brought against BT by Mr. Appellant on behalf of BT consumers, essentially turning on the pricing of products by BT, and there was a renewed application which was heard with full argument by substantial teams of counsel, as one sees from the cover page. And the tribunals set out its statement of principle, really, in relation to the evaluation of evidence and inference of fact at page 534. Paragraph 12, as under the Subsidy Control Act, the Court of Appeal has jurisdiction in appeals of this sort only on points of law. It explains where errors of evaluation of evidence can be characterised as an error of law. The halfway down, paragraph 12, this court has to ensure that it does not, without good and proper reason, interfere in the exercise of the legitimate discretion of the CAT to find facts, draw inferences from those facts. Both the nature of the evidence and the institutional composition of the CAT are factors affecting the breadth of the margin of discretion that must be accorded to the CAT. This impacts upon the sorts of alleged errors that the court will recognise as amounting to viable grounds of appeal. There's then subparagraph 1 dealing with the individual facts of the case. And then secondly, the CAT has an institutional ability on the bench to meld legal, financial, business and economic experience, a range of skills not systematically replicated in the appeal court, which are especially important in cases such as the present, given the nature of the evidence. We say that's applicable here. As you're aware, Mr. Malik, KC, sat with two members of the CAT who both had substantial experience in property and investment in property. That wasn't by happenstance, that wasn't by accident. Mr. Malik explained to Mr. Barrett and myself at a case management conference in April last year that the timing of the hearing was specifically set to ensure the availability of those two wing members because of the experience and expertise they brought to the tribunal. One of the points that's noted in the judgment is that there was no expert evidence adduced by either party in front of the CAT. My learned friend at the first case management conference, which took place in November 2024, was given permission to adduce expert evidence, but in the event chose not to do so. Our observation on that was essentially we thought that given the evident expertise on the tribunal, it was difficult to see how some external expert could assist the tribunal in its decision making. The expertise was there in the tribunal. It's not one of those cases where you need an external expert. And so that's an important point, that the CAT has the advantage of that expertise in its institutional composition, and that is a factor that, as the Court of Appeal has said in the Patorel, affects the breadth of the margin of discretion.
I find the word discretion slightly discordant in that context. Normally, findings of fact would be regarded as discretionary matters, and assessments of evaluative questions wouldn't be regarded as discretions either.
Yes, was this a sensible way of going about seeing whether these were investments on commercial terms? And of course, the tribunal itself had two experts, as we'll go on to see when we go through the tribunal's judgment. The authority itself had external experts, both at the Gateway panel meeting, 3 external experts, and at the credit meeting, 1 further external expert. And they are appointed to give that external input into decision making, so that if matters are proceeding on a commercial basis, you've got people with the relevant expertise who can call that out. So we do say that this court should give due weight to the expertise of the tribunal in carrying out its assessment of the evidence before it. And that in fact, the points that are being run by my learned friend today are essentially a little more than attempts to rerun arguments that didn't find favour with the tribunal for reasons that they've given, and rerunning them today in the Court of Appeal doesn't make them into errors of law. They're not. These are matters. These are factual matters which the tribunal considered and largely rejected. So I think that's all I wanted to say about the nature of the review exercise carried out by the CAT.
Well, I think you've taken us to some length to the Patorel and the role of this court, the review jurisdiction of this court.
Yes.
I think you started off by saying your skeleton dealt with what the standard of review before the CAT was, at paragraph 7 to 9 of your skeleton.
Yes.
But the only thing I can find there is a sentence saying, none of this involves the cat substituting its own view for the decision, that of the decision maker, which is the opposite of what the submission I understood you to be making. So, is it your case that the only question here was whether the cat was right or not to determine for itself that this is not a subsidy? Was its decision that this is not a subsidy itself right or wrong? That's the only question for us, is it?
Yes.
But where in your skeleton do you set out what the cat's job was in this case?
The cat's job is obviously to apply judicial review principles.
But I thought you said it wasn't, because this is a precedent fact case.
It's whether or not there's a subsidy is, we've been using the phrase precedent fact, it's an objective assessment. And then within that, as we'll see when we look at the cases, there are a range of views that can be taken about commercial investment that don't involve granting of subsidy. If you bear with me, so it's essentially a submission that the CAT is entitled to bring its expertise to bear in reviewing the decision-making process. That's the point that's being made at paragraph 12 of the Paterel.
Isn't that, I thought what they're talking about there is the extent to which this court should interfere with decisions made by the CAT. In that case, the CAT is making an original decision, I think, because it's making decisions, I think, about the law, competition law, whether something was anti-competitive. Here, there's a different question, which is what was the role of the CAT in relation to the decision of the public authority? What was its proper role? I don't think that's answered by the Paterel case.
So I think the best assistance that can be gained on that is from the Zacaroli case, which was cited by the CAT. And that is perhaps best summarised by Mr. Justice Simon in the Spreadex case in the Authorities Bundle, tab 20, begins at page 640. And this is a challenge before the CAT on judicial review grounds to a competition and markets authority merger prohibition decision. And the role of judicial review by the tribunal is addressed by the tribunal at page 600, starting at page 649.
49, so
649, page 649 at tab 20. And a judicial review. And there's quite a lengthy challenge because essentially Spreadex was saying the CMA couldn't rationally have come to the view that its acquisition should be prohibited under the merger control provisions of the Enterprise Act 2002. The CAT in that case, chaired by Mr. Justice Siney, sets out from paragraph 48 onwards summary principles from an earlier CAT case, Appellant. Paragraph 49 notes the broad nature of Spreadex's rationality challenges. It's appropriate to identify different ways in which a rationality case can be advanced. In modern public law, rationality challenges have come to be classified into two broad headings. So an applicant may complain that a public body has erred in the process of reasoning, each decision, sometimes referred to as process rationality, or the applicant may complain about the outcome, sometimes referred as outcome rationality. Then we see in paragraph 50 the summary of process rationality. Halfway down, another more practical way of putting this is to ask whether the body's conclusions follow from the evidence or whether there's an unexplained evidential gap or leap in reasoning which fails to justify the conclusion.
That's explaining a logical error, but process, he says in the first sentence that it includes the well-known requirement that the decision maker must have regard to all mandatorily relevant considerations and no irrelevant ones. And then he goes on to say, and in addition, it's a logical error point.
And then paragraph 51 deals with outcome rationality. And paragraph 52 on the question of the rationality standard more generally. And there we see Cerelia, I'm sure I'm mispronouncing, which was an appeal to the Court of Appeal actually from a decision of the CAT chaired by Mr. Malik, KC. Mr. Malik drew this case to our attention before it. And we see there the specific elements concluding the bottom of 652, paragraph 53. It's important to note that nothing in Cerelia suggests that a review is a form of merits appeal. It remains a review on the principles we've set out. As he explained, the deep dive, to which Justice Green made reference in Cerelia, is undertaken for the purpose of the tribunal performing the limited judicial review function and not for a larger appeal type purpose. And then over the page, it also cites the B Sky B case, another one which I was junior counsel and unsuccessful in that case as well. So I think that's the assistance I can give this court. That might be getting all sorts of approbation from outside for my.
I think it's the London legal war coming to an end, and it is a bit noisy. But thank you. How are you getting on?
I'm according to timetable, I think. So I'm happy to resume at 10:30 tomorrow morning if that's convenient.
Very well. 10:30 tomorrow.
All right, if able.